A Section 8 landlord in Connecticut was accused of retaliation for filing an eviction against the tenant after the tenant says that the landlord filed the eviction only because they were reporting housing code claims. But here's the catch, right? The tenant, their voucher payments were no longer going to the landlord. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I have a kind of complicated story for you coming out of Connecticut, and it has to do with this eviction trial between a tenant and a landlord. And the whole situation, it's kind of messy. It's kind of a long article. It's really interesting, though, because, it goes into a couple of things that are really interesting to the people who watch my videos. Section 8 tenants, the housing authority, the payments that you receive from them, the inspections, a lot of the stuff that I talk about, the reasons I would never want to invest in another Section 8 tenant is because of the things that are going on here. Now, also it covers things such as good cause eviction laws, because this tenant decided that they wanted to allow the lease or, the month-to-month lease that this tenant was on just to expire, and had to take the tenant to court and file an eviction in order to do so. Now, that's just beyond what I believe should be necessary, but in Connecticut, it is necessary. So, this whole situation, it's messy. It's a really good story, though. So before I get into the article, go ahead, hit the like, subscribe button, maybe leave a comment down below. Let me know what you think. So, have you ever been accused of retaliation by a tenant? Okay, now, the judge in this case did not agree with the tenant and says, hey, this was not retaliation. The landlord had every right to do what she did, and you have to get out of her unit. But you know what? It's easy for a tenant to claim that any action that you take, whether it be positive or negative, is retaliation. Okay, so in my opinion, those anti-landlord retaliation laws are ridiculous, and they shouldn't be even on the books, because you know what? It prevents a landlord from being able to raise rent or evict a bad tenant or do anything that could possibly be construed as retaliation. But anyway, let me get into this story. It's long, so I want to get into it quickly. This article is coming from the New Haven Independent, and it says, Judge rejects retaliation and approves eviction. The good thing is the landlord won in this case, but the hoops that the landlord had to jump through to win, they kind of suck. But anyway, let me get into the story. A 2-day eviction trial that revealed how emotionally fraught a long-term tenant-landlord relationship can get has culminated with a judge ordering the renter to leave because her lease has expired. The legal debate at the trial centered on what counts as landlord retaliation. The judge found that a tenant can't succeed with such a defense unless she proves that a landlord's primary motive in taking her to court was to punish her for speaking out about housing code concerns. And as I've mentioned many times before, you would be an idiot if you as a landlord just said, hey, went up to the tenant and said, hey, I'm retaliating against you because of something you did. Instead, you find a different reason, and a reason that is within the limits of the law, in order to get rid of that tenant. And that's exactly what this landlord did here, and that is why the landlord won the case. It is not provable that this was a retaliatory action, even if it was, okay? State Superior Court Judge Alina Stone handed down that 5-page decision on Monday in the eviction case Vorsilia Oliphant Mocker versus Shelley Thompson. The judge's order, which can be read in full here, comes a full month after the trial took place on January 30th and February 3rd in the third-floor housing court at 121 Elm Street. The case itself dates back to July 2024, when Oliphant Mocker, who lives in Meriden, sued to evict Thompson from her apartment in a 4-unit building on Cherry Ann Street because Thompson's month-to-month lease had expired. Oliphant Mocker has owned that building since 1999 and has rented to Thompson since 2008. So keep in mind, you've owned the building since 1999. So you've owned this building for 25 years. You've had this tenant in there since 2008. From 2008 to 2024 is 16 years. So this tenant has been your tenant for an extremely long period of time. And so it's hard to believe that, hey, this is a bad landlord who just, is evil, okay? If you were in this place for 16 years, it's probably because they had a good relationship at one point in time. But what led to the end of this relationship? And that's what I'm going to get into. That's what has to do with the Section 8 program. And that's the real reason I believe that this tenant was evicted. But let me continue. In September of 2024, Thompson and her legal aid attorney, Jonathan Zamir, pushed back by arguing that the landlord's eviction lawsuit constituted retaliation. The lawsuit came within 6 months of Thompson raising concerns with the city's Livable City initiative about conditions and problems at her Newhallville apartment. The housing authority wound up canceling Thompson's Section 8 rental subsidy to Oliphant Mocker last May after 3 consecutive failed inspections relating to those very same unfixed concerns. Among those problems were a leaky ceiling, cracked windows, and a smoke detector in need of repair. Over the course of the trial, Oliphant Mocker repeatedly said she wanted access to the unit to check on the smoke detectors and claimed that Thompson wouldn't let her in. So, here is, what happened, basically, okay? The tenant called in for, saying, hey, there's problems here in the unit, and this landlord's not fixing them. But they came in to do checks on the place, right? And she failed the inspection. So what does the landlord do? The landlord needs to get into the unit in order to fix the problems. And she won't let the landlord in. And I don't know what the strategy is by not letting the landlord in to repair the problems. Maybe thinking that, I can get some sort of free rent or something, right? But wouldn't let the landlord in. So after 3 or however many failed inspections, guess what? The Section 8 program says, hey, we're not going to pay you anymore because you didn't pass your inspection. And there we go. That is the reason why the tenant was evicted. Basically, the tenant wasn't paying the full amount of rent, and the property failed the inspection, which, believe me, my property failed the inspection too. I just was able to get into my property while I was a Section 8 landlord and get all those things repaired before they stopped paying me. Okay, so this is a common thing that happens. Now, it's unfortunate, but once they canceled the Section 8 payment to the landlord, all of a sudden the landlord's paying out of pocket to house this woman for free. So yes, I would terminate her lease immediately. I'm like, hey, I'm not getting paid. My job isn't to house you forever. So therefore, you've got to go. Okay, so like I said, I don't know what the tenant's logic was, but if she was trying to force repairs onto the landlord or somehow punish the landlord, thinking everything was going to be all right, that was a foolish thing to do. This also goes back to, there needs to be tenant turnover. Landlords, it's a hard time for us to keep a property updated and in good repair when a tenant is in a property for a very, very long period of time. She was in this unit for 16 years, right? So the place was probably dated. It had probably had a ton of deferred maintenance. And, if there had been regular cycling through of tenants, like every few years, like I had on all my apartments, right? Then every time you put a new tenant in there, you go in there, you put new paint, new flooring, you fix all the broken stuff, and then you get the new tenant in there. But because she had been in there so long, that's why it seemed like there was a lot of deferred maintenance. But I'm not making an excuse for it, but this is what you see in places where you have tenants in a property for a longer period of time, okay? Anyway, let me continue. In her decision on Monday, Stone wrote that there is no evidence that the plaintiff's primary motive in initiating the eviction action was due to the defendant's exercising of her statutory rights and communicating with LCI or the housing authority about needed repairs at her apartment. The judge wrote that the eviction lawsuit also did not stem from the landlord's loss of a rental subsidy from the housing authority because of failed inspections. Instead, it was brought because plaintiff is and has been very concerned that all of her units have working smoke detectors and is tired of fighting to get access so that she can ensure that the smoke detectors are functioning properly. Accordingly, defendant's special defense of retaliation fails. So she was able to prove to this judge, well, I don't know if the judge truly believed it or just has to take her word for it, that she was removing this tenant because she was unable to access the unit to make repairs to these smoke detectors. Okay? Now, if that's, remember, we're not done. Okay, as long as if you go to court and you say, hey, this is the reason I'm removing the tenant, right? And you don't say, hey, I'm removing the tenant because I'm not getting paid anymore. I'm removing the tenant as retaliation for all the bad inspections. If you just say, hey, I'm removing the tenant for this other reason, and then you just stand by it, you know what? The judge has to take your word for it and has to decide with you. The problem is when you talk too much, or maybe you sent a text message, laying out that you wanted revenge or something stupid, right? Like I said, you can easily win these eviction cases if you just keep your mouth shut. Okay? Keep your mouth shut. Now, she defended herself in this, and she did a pretty darn good job, in my opinion, because she was able to convince the judge that, hey, you know what? I'm doing this for a reason that is actually covered by the law. And by doing that, she won. And this tenant has to go. And simply put, in my opinion, the whole situation, it's ridiculous. You shouldn't have to go to court to remove a tenant on a month-to-month lease. That's dumb, okay? What kind of state has a law that says, oh, you know what? This tenant's on a month-to-month lease. You just can't tell them, give them appropriate notice, of course, and just say, hey, I'm not going to be renewing. You're going to have to find somewhere else to live. Not have to go to court, and fortunately she was able to defend herself. But in a lot of places, you got to hire a lawyer. Okay, you got to pay hundreds or thousands of dollars in order to do this. So that should be pretty simple. Get rid of this tenant. And she's been trying to get rid of this tenant since 2024. Okay, as of right now, it's April of 2025. So how long has she not been getting paid from the Section 8 Housing Authority? Okay, how many thousands of dollars is she out already? This is exactly my point, okay? But anyway, tell me what you think of this. I'll put a link to the article in the description down below.